Hi, I'm Sean Sullivan, a partner at Alston & Bird's healthcare regulatory practice. I spend a lot of my time working with providers, healthcare technology companies, and investors as they think about how to use health data to build smarter products, improve care, and create new revenue streams, while staying on the right side of healthcare regulations. When clients talk about health data monetization, my focus is often on how these data strategies intersect with core healthcare regulatory rules and not just privacy. In particular, three areas come up regularly: fraud and abuse, especially under the federal anti-kickback statute, information blocking under the 21st Century Cures Act, and, in some cases, corporate practice of medicine or SPOM rules. Now, none of these are barriers to innovation, but they do shape how data-driven business models need to be designed. The anti-kickback statute comes into play whenever something of value is exchanged in a way that could influence referrals or utilization reimbursed by federal healthcare programs. As data becomes more valuable, regulators increasingly view data, analytics, and insights themselves as things of value. Risk can arise, for example, if data access or analytics are provided for free or at a discount to drive downstream business, if payments tied to data are linked to volume or value utilization, or data-driven tools are structured in ways that steer clinical or referral behavior. That doesn't mean that data monetization is off limits. It just means that the economic logic and the incentives matter. The good news is that there are well-established ways to structure data arrangements responsibly. Key principles include making sure compensation reflects fair market value, avoiding financial terms that reward or depend on referrals, being clear about what data is being provided, for what purpose, and to whom, and evaluating whether any safe harbors may apply, even if the model doesn't fit perfectly. Just as important, regulators look closely at how arrangements operate in practice, not just how they're described on paper. Alignment between legal, compliance, and business teams is critical. Information blocking is an area that many organizations don't fully appreciate until they're deep into product design. Under the Cures Act, certain actors, including providers and health IT developers, generally cannot interfere with access, exchange, or use of electronic health data unless an exception applies. Data monetization strategies can raise questions if access to data is restricted to protect commercial value, if fees are structured to exact leverage rather than to recover costs, or if data is withheld to preserve proprietary analytics or platforms. In other words, monetization goals can't come at the expense of lawful data access. No, charging fees is allowed, but the rules require that the fees be objective and reasonable, based on actual costs, not strategic value, and applied consistently. Where companies get into trouble is when pricing or access restrictions are designed primarily to protect a monetization strategy rather than to support legitimate operational needs. This is an area where thoughtful design early on can avoid real problems later. Corporate practice of medicine issues can arise when data and analytics begin to influence who controls clinical decision-making. That risk shows up when non-physician entities use data tools to direct or pressure clinical choices, when compensation tied to data insights affects how care is delivered, or when technology platforms effectively dictate physician judgment through algorithms or through incentives. As data becomes more embedded in clinical workflows, CPOM analysis increasingly overlaps with data strategy. The key takeaway is that health data monetization is absolutely possible and increasingly necessary, but it has to be designed with healthcare regulation in mind. The most successful organizations bring regulatory perspectives in early, not late. They design business models that align incentives appropriately and treat compliance as an enabler of sustainable innovation, not an obstacle. When that happens, data strategies are far more likely to scale and to last. Thanks for listening. If you have any questions about how fraud and abuse, information blocking, or CPOM issues affect your health data monetization strategy, feel free to reach out to me or another Alston & Bird attorney.